So let's take, we will take one of the two. We can't take the three. That is how we can't take adverse possession with the two. So maybe we start with anyone that is ready among them, tort or contract, after adverse possession.
Okay, sir.
So Madam, adverse possession.
Yes, sir. Okay, sir.
How many of your members are in class?
We are 4 in number, sir. Yes, sir. I want to believe they are all online. Okonkwo Luke, Nnamdi. Please, if you are there, can you speak up? Azufaloye Judith Chukuka.
Present.
Okay,
I'm
thank
present.
you. Then we have Nkemi Yoma.
I'm here. Yeah, present.
Okay, thank you, Kim. So sir, my name is Adironke. Yes, sir.
Note the one that is not present.
Okay,
Class
sir.
captain, please note the one that is not present too. So
sir, yes, sir.
Okay, sir. My name is Adironke Jalade Akinwande.
Okay.
Yes, sir. For
Yes.
Yes, sir. So our topic is adverse possession and prescriptive title to land. And for our group, sir, Nkem would be making the presentation, sir.
It's all right.
Please,
all right,
Prof,
Nkem, please, you have the floor.
Please, I'm here. I'm here.
Okay, Mr. Okonkwo.
I'm here. I'm here.
Okay, sir. Sir, we are complete now, sir.
Okay. Class captain, take note.
Thank you, sir.
Members of the group were complete on the day of presentation. So let's go on. Let's go on.
All right, Nkem, please, you have the floor. Thank you.
Thank you. Good evening, Prof, and good evening for me. Our seminar topic is adverse possession and prescriptive title to land. Now, the concept of adverse possession and prescriptive title have remained some of the most debated doctrines in land law. A lot of issues have been raised concerning these doctrines. Can you hear me now? Can you hear me?
Try and increase your volume, but to me, I'm hearing you.
Okay. I'll try and speak louder. Thank you, sir. Okay, our presentation is divided into 4 parts. We are going to be looking at the definition, the introduction, definition of the concept. We'll look at the statutory provision. We'll compare the principle in Nigeria with that of other common law jurisdictions. Then we'll give our recommendations and conclude. Now, adverse possession, the concept of adverse possession involves a person who occupies another person's land, possesses it continuously, openly for a certain period of years, and will be able to obtain title to that land after being in possession of another person's land for a particular period of years without the real owner taking action to recover his land. Now, in defining adverse possession, we say that it is a legal principle that allows a person to obtain full ownership of another person's land simply by occupying. Yes, sir.
Go on, please.
Okay, simply by occupying and using it openly, continuously, exclusively, and without the owner's permission. Now, prescriptive title to land, on the other hand, is a non-possessory right to use another person's land for a specific purpose. And unlike adverse possession, where ownership can be notoriously acquired. For example, if a neighbor continues to use a path across their neighbor's land for a long period, he might acquire a prescriptive title for that path, which means that the neighbor cannot block access to that path. Maybe a person has a land at the back of another person's house, and in entering, I want to enter my house, I pass through my neighbor's, frontage or a path of his land. After using it for a particular period of time, that neighbor cannot come and say he wants to block my access to my land, to my property, because I've been passing through his land. Now let's look at the historical background of adverse possession. The pre-colonial period. Now, before the advent of colonialism in Nigeria, the land was primarily governed by customary law. And in this period, land was administered by family heads, village chiefs, community leaders, and so on. It is these heads of families of villages that distribute land to family members. And the ownership of land endured in perpetuity during this time. Now, we all know that during the pre-colonial period, two of the most common ways of acquiring land was through settlement, forced settlement, or conquest, or even by gift. Now, the concept of first settlement does not include a person extinguishing another person's right to land, just like in the case of adverse possession. Now, what are the legal foundation of adverse possession in Nigeria is now principally derived from the English common law. Now, when during the colonial period, the British introduced common law, they received common law, which was now the means of administering land in Nigeria. Now, these statutes reflecting English legislation spells out a period within which a rightful landowner must assert their right to claim property from an unauthorized occupier. Now, if this owner fails to do so within that specific period, he will lose his right to his property. What are the elements of adverse possession? The first is that the adverse possession must be in actual possession of the land physically. Continually, must be there. People must see him that he is actually in possession of the land. Now, periodic hunting, going to hunt on the land, for example, or coming to do one activity or the other and living for a particular period of time will not amount or qualify an adverse possessor to obtain title to land. Secondly, open and notorious. The person occupying the land must act as the owner by engaging in acts consistent with the property's purpose. Such acts must generally be observed by others to be typically of that expected by the owner. He must act on the land. He must, carry out activities openly as though he's the actual owner of that land. Now, the person occupying the land must do so exclusively, not sharing the land with the true owner or with the public in general. And also, the adverse possessor must also place some restrictions on the land. He must carry out activities like he's truly the owner of that land for that long period of time. Now, the person possessing the land also, the property, makes a claim that is based upon a legal error, which in turn leads him to believe he's the actual owner of the property. What that means that for an adverse possessor to obtain title to a particular property, he must be based on the fact that the actual owner has slipped on his right, has refused to take action to recover his property over that very long period of time. Then he can now be able to, proceed to take to obtain rights to that property. Now, continuous and uninterrupted. All the facts defined by law must occur during the statutory period for the possessor to fully claim the land. Now, let's look at prescriptive title, historical background. Prescriptive title is often used interchangeably with adverse possession when referring to the acquisition of land ownership through long, unchallenged possession. However, it can also refer to the acquisition of easements and other rights over land through long usage. Now let's look at the customary law analog of long possession. Under customary land law, while not explicitly termed prescriptive title, the concept of long possession or first settlement was a fundamental way to establish ownership of land. If a person or community occupies and uses land for an extended period without dispute, their claim to ownership or strong infrastructure rights would be recognized. Now, through of title by traditional history is an important aspect of Nigerian customary land law, and it involves establishing ownership through historical accounts of how the land was first owned by their forefathers through conquest, first settlement, and now it has been passed down from generation to generation down to the person. English common law or English common law influence. Now, the English Prescription Act of 1832 and common law prescription principles of prescription were introduced, primarily dealing with acquisition of easements like right of way and profit appendage, which is the right to take something from another person's land through long and uninterrupted enjoyment. This principle established specific periods, for example, 20 or 40 years of easement, 30 or 60 years for profit, after which such rights could become absolute and indisputable. Now, let's look at the Nigerian adaptation. In Nigeria, the concept of prescriptive acquisition of rights is recognized drawing from the inherited or the received English common law and statutory principles. However, when Nigerians speak of prescriptive title to land, we mostly refer to the operation of adverse possession because those terms are commonly used interchangeably here in Nigeria, where long undisturbed possession of land itself leads to the extinguishment of the original title and the acquisition of a new title by the possessor. The limitation laws are the key statutes that govern this process here in Nigeria. Now let's look at the theoretical foundation of the concept of adverse possession and prescriptive title. From a jurisprudential perspective, adverse possession is underpinned by utilitarian and economic theory, which prioritize the productive use of land over dormant legal ownership. According to this, the long-term occupation by a squatter who makes use of the land in a visible, continuous, and wholesome manner should, after a statutory period, be recognized by the law to encourage certainty and efficient use of land. The Lockean labor theory of property also plays a fundamental role, which posits that ownership can arise from the investment of labor by cultivating, developing or maintaining the land. The adverse possessor arguably earns a legitimate claim. Furthermore, further social stability and public interest in resolving land disputes and clarifying titles reinforce the need for doctrines that do not perpetually reopen old claims. Now, what are the legal foundations of adverse possession and prescriptive title to land in Nigeria? Now, adverse possession and prescriptive title have their legal roots in the received English common law and statutes of general application. The Nigerian legal system, being a blend of customary law, English common law, and statutory law, inherits the doctrine primarily from the English Limitation Act of 1833 and its subsequent recapitulations. The principal statute governing adverse possession in Nigeria is the limitation law of various states. For instance, in Lagos State, the limitation law of Lagos State 2015 provides that action to recover land must be brought within a period of 12 years of the course of action occurring. Section 6 of the law bars the right of a landowner to recover possession after 12 years of adverse possession, effectively vesting possessory title in the squatter. Now, what this means that when an adverse possessor is in possession of a land openly, continuously for a period of 12 years, without the real owner of that land going forward to take action in order to recover, reclaim his land, that adverse possessor, after a period of 12 years, can move forward to, obtain title to that particular property. However, the application of adverse possession in Nigeria is complicated by the Land Use Act. Now, the Land Use Act vests all the land in each state in the governor, and the governor of each state holds land in trust for the benefit of all Nigerians. Now, the Act has raised questions about whether title can be extinguished merely by possession against the state, and whether a person in adverse possession can apply for a right of occupancy under the Land Use Act. Now, let's look at the justification for adverse possession. What are the justification of adverse possession? It is clear that a claim on which has no action has been taken for a long time may cause hardship to the defendant. Now, the concept of this adverse possession and prescriptive title has their advantages and disadvantages. Some people have said, oh, it is good so that it preserves land. People can use land for the purpose of which the land has been obtained. And some people have said, no, that it actually causes hardship on the person who first owns the land. That is, without knowing the reason for a person not taking action to recover his land over that period of time and extinguishing that person's rights, it can actually cause hardship, and that principle should be scrapped out. That is what some people are persistent. Some people are saying, no, it shouldn't be. While some are saying, yes, actually, it is good. Now, even in the context of vested property rights, it may be thought that to assert right and title after the passage of a very long time may be immoral. It may even be that a claimant could take advantage of a lapse of time to press a claim that had no merit in the first place. The logical extension of this argument is that those who are dilatory in enforcing their property rights are to be punished by having their property taken from them. Now, where the law allows an adverse possessor to acquire title, the policy can be said to protect the interest of those persons who utilize the land as fully as possible. Even where the possessor does little with the property, at least he has done more than the actual owner, who has done nothing at all on the land. The utilization of land is valuable to a society. While this is perhaps the best argument in favor of adverse possession, there must be some caution to ensure that the privation of an owner's vested property rights does not occur in a filthy or otherwise unfair manner. Now, people are saying, oh, that it should, before extinguishing someone's title and granting another person title to land, they should properly look at the circumstances of each case so that the decision will not cause hardship to one party. So we'll go to part 2 of our paper, Statutory and Judicial Framework. The principle of adverse possession continues to operate in Nigeria largely under the framework of various state limitation laws. Here we have said it before that the Limitation Act of each state in Nigeria is the statutory framework basically governing adverse possession, and it has stated expressly that for a person to be able to obtain right to a property, you must have been in full, continuous, notorious possession of that property over a period of 12 years. Now, here's a breakdown of the effects of the legal statutory framework for adverse possession in Nigeria. Number 1, extinguishment of the original owner's title. The primary effect of the limitation laws in this context is the extinguishment of the true owner's title to land. If the rightful owner sleeps on their rights and fails to take action to recover their land within the statutory period, their legal interest in the property is lost by operation of law. What this means is that even if they had a perfectly valid title before, that title becomes unenforceable against the adverse possessor once the limitation period has expired. Secondly, the acquisition of title by adverse possession of prescriptive title. Once the limitation period has run, the adverse possessor, who has been in continuous, open, notorious, exclusive, and wholesale possession of the land, can acquire legal title to it. This is often referred to as quarters right. The acquisition of title by adverse possession is automatic by operation of law once the conditions and statutory period are met. The adverse possessor doesn't necessarily need to go to court to get a declaration of title. although they may do so to formalize, their ownership. Now, the statutory period in Nigeria, the Act generally sets a limitation period of 12 years for an individual to bring an action to recover land from an adverse possessor. Now, encouraging productive use of land. One of the underlying justifications for adverse possession and limitation laws is to encourage the productive use of land and prevent land from remaining idle, neglected indefinitely without any improvement being made on the land by the owner of that land. So the law effectively punishes owners who fail to vigilantly protect their property rights, and gives to the grant the right to that land on the adverse possessor. Legal certainty and quieting of titles. Now, the limitation laws contribute to legal certainty and the quieting of titles. They prevent stale claims from being brought many years later after the fact, when evidence may be lost, memory faded, parties must have died, and their children and the children after them will be the ones to inherit these cases. This ensures that land ownership can be settled and relied upon. Now, we'll look at the breakdown of the role of Land Use Act on adverse possession in Nigeria. First is that the Land Use Act vests the land in the governor. This means that the individual no longer holds absolute ownership of land, just as it was during the time where the customary law was in full practice. But rather, what is granted now is the right of occupancy. Now, the impact of title for adverse possession. Previously, adverse possession operated by extinguishing the original owner's title and conferring a new one on the adverse possessor. But now, with the Land Use Act, the concept of a direct title to land as held by individuals has been altered. The governor now remains the ultimate owner of the land, and what individuals can now have is the right of occupancy. Now, despite the change limitation period, despite the change in land ownership structure, the Land Use Act also implicitly acknowledges adverse possession by setting time limits within which land recovery must be initiated. We have said that severally, that the Limitation Act of 1966 provides that the period from which a person can obtain title to land after being in possession is 12 years. Now, the role of Land Use Act involves centralization of land control, which means that land is now fully administered or governed by, or vested on the governor of each state. Now, secondly is the introduction of right of occupancy. Now, there is no absolute ownership of land. Under the Act, individuals no longer hold absolute ownership of land. Instead, they are granted a right of occupancy. And the evidence of this right of occupancy is the granting of the certificate of occupancy. Now, impact on land transaction and development. The governor's consent. A crucial requirement under the Act is the need for governor's consent for any alienation, sale, mortgage, or lease of land. These has created a bureaucratic process. Intended to prevent land hoarding. Now, the Act was also intended to prevent land speculation and hoarding by making land more accessible for productive uses like agriculture, housing, industry, and so on. Facilitating public projects. By centralizing land control, the government gains power to acquire land more easily for public purposes such as infrastructure, urban development, and so on. Compensation for land acquisition. When the government revokes a right of occupancy for public purposes, the Act now provides for compensation based on the value of unexhausted improvements on the land. For example, building, crops, and not the land itself. This has often been a point of contention and legal ambiguity. Now we'll go to part 3 of our paper, which is comparative jurisdictional analysis, how the adverse possession and prescriptive title to land are treated in other common law jurisdictions or countries. Now, I said the start on statute of limitation in both common and civil law jurisdictions mandated by Her Majesty Court Service after the controversial case where a counsel appearing in a human rights case before the European Court of Human Rights in J.A. Pye Oxford Limited versus the United Kingdom. The United Kingdom appealed against the decision of 15th November 2005 to the effect that failure to provide compensation for loss of title to land on expiry of a statutory period violates Article 1 of Protocol 1 of the Human Rights Convention. So researchers were asked to provide first the original text and the translation into English of the legal provisions relating to the length of limitation act and prescription periods for the acquisition of title to land by adverse possession. Secondly, a summary of the most important case law, if there is any, based on provisions. Now, also the limitations, in particular, the following questions are to be considered. First is, the limitation or prescriptive period differ depending upon whether adverse possession is a good faith. Second is, compensation available to those who lose their title to land at the end of the limitation. So let's look at Australia. Now in Australia, rights in relation to land are determined by the laws of respective states and territories of Australia. While the laws of Australia Capital Territories and the Northern Territory do not recognize any loss of title to land by adverse possession. Now, each of the states in Australia will recognize a proprietary interest held under adverse possession, and depending upon whether the land is registered or not. Now, if the land is registered, an action by the real owner to recover it may be brought within a period of either 12 years, that is in Queensland, NSW, Queensland, Western Australia, and Tasmania, or 15 years in Victoria and South Australia. Now, once that period has lapsed, the title of the person disposed will be extinguished. The title of the person disposed will be extinguished. In the respect of registered land, owner holds the land subject to any right of adverse possessor in all those jurisdictions. Good faith is not a necessary or sufficient for the acquisition of title by adverse possession, and there are no rights to compensation for the original owner who has lost his title. In New Zealand, the right of adverse possessor depends upon whether it is registered or unregistered. Title to unregistered land can be extinguished after 12 years of adverse possession, and it is provided in the Adverse Possession Act of 1950. The period is extended to 60 years, where the action to record land is brought by the Crown, while Limitation Act does not apply in Maori customary law. A 12 years limitation period applies if any action to recover such land is brought against the Crown. Now, where the land is registered, the adverse possessor can apply for certificate of title after 20 years under the Land Transfer Amendments Act of 1963. A certificate will then be granted except another person establishes title to the same land. Evidence of good faith is not a requirement under the law of New Zealand, and there is no provision for compensation for a person who lost his title under adverse possession. In Canada, rights in relation to land are regulated by the laws of the state and provinces and will vary depending upon whether the land is registered also or unregistered. Where the land under the why adverse possession is recognized after 10 years with respect to unregistered land, adverse possession does not apply to registered land. Where an action to recover land is brought to the Crown by contract, a 50 years limitation period applies. No time limitation in respect of waste or vacant land for the Crown. Similarly, time will not run in respect of any allowance for public highways if the freehold is vested in the Crown or public body. Evidence of good faith or lack of...
Dear presenter. Hello, presenter.
Yes, sir.
Can you please conclude? Can you please conclude?
Okay, sir.
Conclude. We've heard all that we needed to hear. Even though I've not read
so
your
let me
paper
just,
before, so I could not guide you on
okay,
what
so
we
let
need
me
to
just
hear.
go. Let me just go to the recommendations, sir. So for our recommendations, first, we propose a reform of the doctrine to make it fairer and more equitable. The aim of the proposal reform is tailored towards conferring additional protection on the registered landowner against undeserving adverse possession claims in a manner which preserves certain valuable functions performed by the doctrine. Second, the introduction of service of notice will help ensure that property owners are aware of adverse possession claims and can respond accordingly. Thirdly, there should be a reform that could prioritize protecting vulnerable groups, such as those with limited access to legal resources and with low income. And lastly, reform should ensure adequate compensation to original landowners. Thank you, sir.
Okay. I've listened to group 7?
Yes, group 7.
Yes, sir.
So can we have comments? She spoke to us about their seminar, spoke to us about adverse possession and prescriptive title. The first question I want to ask them is there any difference between adverse possession and prescriptive title? Group 7.
Yes, sir.
Is
Yes, sir, we are
adverse
here.
equal in all respect to prescriptive title?
So you said, is there any difference between the two terms, sir?
Yes, adverse possession, prescriptive title.
Yes, sir. For adverse possession, sir, somebody takes absolute rights and enforces title over another person's land. And then for prescriptive, sir, the person does not acquire the right over that land, but is permitted to use the land.
What did you say is the difference? In adverse possession, you say the person.
Yes, sir. In adverse possession, sir, a person over the years that has been in full occupation of another person's land can have right and title to that land eventually if the time provided or prescribed by law has elapsed for the real owner to take full possession. And then for prescriptive, sir, for if somebody, for instance, uses a particular portion of land, for instance, like we cited in our papers, as a passage, probably as neighbors, and over the years, it's what they have been having access to in the neighborhood. The person does not automatically get entitled to that space, but has rights to make use of that space, sir.
Okay. Yes. Any contrary view from members of the class?
Not really, sir. Just an addition. In adverse possession, the adverse possessor can obtain a right to that land. So it extinguishes the previous owner's title to the land. But in the case of prescriptive title, the person only has a right to use just a particular portion of the land, maybe as easement to his own property. I'm not essentially going forward to obtain title to the land.
Is that what the
Yes, sir.
textbook
If
say?
I may add, sir.
I'm not an expert in land law, but is that what the textbook say? Is that what they say as regard the difference between prescription and adverse possession?
Yes, Prof. The adverse possession has to do with full ownership. somebody obtaining ownership from the land as a result of the other party sleeping on his right, licensing acquisitions, then he obtained full ownership. But whatever one has to do with right of usage, like easement, to
Yes,
use the easement or the right of way. That's prescription.
Are you suggesting that the difference is in the aggregate of rights allowed? That when you call somebody an adverse possessor, he possibly has more recognized rights, including the right of ownership, as against the person against whom he is in adverse possession. Whereas, if you say a person has merely a prescriptive title, what he has is just one of the constituent rights that make up ownership, which the law has recognized. Is that what you are suggesting? Hello?
Hello, sir?
Yes, sir. Yes, sir.
Well, maybe the textbooks are saying something different from my own understanding. Okay, but let's
What's your
have other
understanding, sir?
rules. Eh?
What's your understanding, sir? Different from what the two speakers have said.
I cannot vary the textbooks, but my understanding of adverse possession is that you are in adverse possession itself connotes that you originally don't have title. Okay? Maybe the land belongs to someone else. Okay? But innocently, whether through conveyance or through gift or whatever, you have been made to believe that you are the owner. So now, if you are made to believe that you are the owner, but you don't possess, you can't be an adverse possessor. But you are made to believe that you are the owner, and you couple that with possession. You are in physical possession, you are using the land, but if the title inquiry is properly done, your root of title will be defective. So two persons are laying claim to land. Okay? The one that does not have the title is, however, in possession. Either that he acquired possession through a wrong person, or even if it is a government grant or anything, but the bottom line is that the real owner of the property is someone else. Okay? The real owner of the property is someone else, but he is in possession in the belief that he had acquired rightly, whereas in reality he has not acquired rightly. So he is said to be in adverse possession. He is in adverse possession against the real owner, the title, the person who is supposed to have the title to the land is in adverse possession against that person. Okay? Now, when you talk about prescription, you are invariably talking about statute. Statute will now come in. Statute will come in to say, sorry, let's go on with adverse possession first. So in that way, he's in adverse possession against the real owner. He is not the owner, but he's in possession. The only thing is that he's in possession in the belief that he assumed possession rightly, legitimately. Okay? There are three Latin terms nec vi, nec clem, nec precario. Those were the things that the presenter was trying to explain. The longevity of the possession, the ignorance of the possessor of an overriding title, and the open exhibition of the ownership of the title, because it is based on his belief, even if ignorantly, that he has a right. Maybe somebody who has no right to sell had sold to him. Okay. Maybe the state has allocated to him the land belonging to someone else. Just anything that shows that he has some semblance of a claim, which is, however, not legitimate, in the sense that somebody else is the claimant of a better title to the land. So he's said to be in adverse possession. Now, two things may happen. The real owner, if he challenges him, he might be able to use his adverse possession as a defense. Because I listened to the presenter talking about laches and acquiescence and all of that. Yes, it's correct. Laches and acquiescence would be available to him as a defense, that what were you looking? So what were you looking when I moved on to this land in my innocent but wrong belief to have acquired it, and I started constructing? Okay? So that is the defense of the equitable defense of laches and acquiescence that he could raise if the real owner challenges him. And there is a customary law component of it, as we can see in cases like Kawo and Cookie Gum and all of that, all of those, where principles equivalent to laches and acquiescence were employed to keep the open user of land who had, however, acquired it, or who had, however, acquired possession of it in the belief that he was acting rightly. So that is one thing. That adverse possession might afford the adverse possessor a defense of laches and acquiescence in equity, or what they call standing by in customary law, as employed in such cases as Awo and Cookie Gum. So this particular one, there is no question of timing there. So you could have been on the land for, say, just 1 or 2 years, but you have done something massive. And as at the time you started, anybody could have approached you to tell you, don't construct on that land. It was not properly sold to you. The person who sold it to you had no right to do so. So that you will refrain or restrain yourself from further expending money on the land. But the owner, if he stands by and watches you exhibit your ignorance without warning you, by the time he chooses to challenge you, equity will offer you a defense. Okay? That's why They call it the doctrine of standing by. Okay? So it's the defense of laches and acquiescence. But the gist of it is that what the law or equity looks at is, in that instance, the conduct of the new owner, the person whose title claim would have overridden that of the adverse possessor. It is his conduct. Okay? It is his conduct that the law is punishing by preventing him from being able to assert his otherwise overriding title as against the adverse possessor. So no particular time is prescribed. So that's why it's not a prescriptive title. No particular time is prescribed as to the number of years or months or the length of time that the adverse possessor would have been on the land. Okay? So you don't call it a prescriptive title, but it is adverse possession, and it is going to afford the adverse possessor a defense if the real owner now takes him to court. Okay? But that is different from prescriptive title. Prescriptive title simply derived from the word prescription. And prescription is done by statute, by formal law. So all of those pieces of legislation that you have under state law that will say that after 12 years or after 10 years, the state limitation laws, they vary. Some of them will say they will prescribe 10 years as the period after which the original owner, the person who otherwise has an overriding title claim over the land, will not be able to do so again. Okay? So that is what we mean. It may have another meaning historically, but that is what is meant by saying that a person has acquired a prescriptive title. If you look at the relevant statutes on the matter, they will first appear to be saying that they have barred the original owner from filing a claim. Okay? Then they will now go on and say expressly that by implication, the title of the original owner has been extinguished. Okay? So then there are some statutes that she has shown to us. There are some statutes that will even entitle the otherwise adverse possessor to obtain a certificate of title from the state for the period, having attained the period of time that the statute prescribes. So prescriptive title cannot exist without one, there being a formal law, like a piece of legislation. And that formal law must prescribe a time, say 10 or 12 years in Nigeria, or other number of years under systems, that the adverse possessor must have continuously remained on the land, nec clam, nec precario. That is, in the strongest belief that is the owner acting openly as an owner and remaining continuously for that length of time. So that is the difference between the two. Okay? Even as an adverse possessor, where the conduct of the person with the overriding title was questionable on the basis of his standing by, watching by, or deceiving you to spend your money on the land in the belief that the land was properly sold to you. The punishment to the real owner is that he will be able to go to court, unlike the case of the prescribed title. He will be able to go to court, but you, the adverse possessor, you will be able to defend yourself, okay, by raising the defense of laches and acquiescence, or what is called the doctrine of standing by, if the tenure is customary land tenure, okay? But where you have stayed on the land for the number of years prescribed by statute, then it is said that you have acquired a prescriptive title. That is you, the adverse possessor. You have acquired a prescriptive title because the relevant limitation law would have formally extinguished the title of the otherwise overriding title owner, because he had refused to take steps within the prescribed time. So that is the slight difference between prescription and adverse possession. An adverse possessor is the person who is in possession of land in the belief that he's also the owner. Okay, whereas there is a stronger claim to the land than is. So it's not the overriding title holder. And since the rule is supposed to be nemo dat quod non habet, he cannot retain the land if he did not acquire from the overriding title owner. So the overriding title owner would ordinarily have been able to challenge him and recover the land from him. But in his defense, he will be able to rely on equity to say that the conduct of the overriding title owner has been unfair. He had stood by. He had watched a person who genuinely believed that he had the right to the property, developed it, and had waited for too long before taking decision. Now, the length of time in this instance is not more important than the overall condemnable conduct of the otherwise overriding title holder. So it is difficult to say this is the particular time. 1 year or 2 years may qualify, depending on the activities that had gone on the land and depending on the actual hello. So depending on the actual imputed or consumptive knowledge that the overriding owner has or ought to have. Okay? So that is adverse possession. But the adverse possession right might ripen into a prescriptive title if it had gone on for the length of time prescribed by statute, limitation statute to be specific. And we have seen the different limitation statutes of different legal systems that the presenters have tried to talk to us about. In particular, in Nigeria, it is either 10 or 12 years. Lagos, for example, it is 12 years. I think in Rivers, it is 10 years. So once you have watched by, you have refused to take steps until after 10 years in a state like Rivers, you lose the right to even go to court. The relevant statute will now say that your title has been extinguished. Okay? So, because a statute has locked you out after a given year, after a given length of time, we say that the adverse possessor has therefore acquired prescriptive title. The word prescription having to do with putting it in black and white as to length of time within which his ordinary possession will ripen into ownership. Okay? So that is the slight difference between the two. Why are we interested in adverse possession and the consequential prescriptive title acquired by an adverse possessor? It is to highlight the point that when we say that possession is 90% of the law, 90% of ownership, these are some of the implications. So somebody who is in physical possession, even if he doesn't have a title, that physical possession, coupled with his innocence, can ripen into ownership. And statute will sometimes make him the owner. Statute making him the owner is why we say he now has prescriptive title. Okay? It is possible that historically, statute will prescribe a person who has gotten accustomed to enjoying some advantages over another person's land, will prescribe him as the owner of that right over the land, in which event a prescriptive title might mean more than or less than prescribing the adverse possessor as the full owner of the land. Because listening to the presenter, that may well have been the difference between the two. Okay? But today, when you are talking about a prescriptive title, you are talking about a title which an adverse possessor acquires by being in possession of land adversely against the genuine owner, okay, for a length of period prescribed by statute, okay? Some of the statutes will go further to even entitle him to now apply. They will entitle him to now apply for a formal document like a certificate of right or certificate of occupancy or whatever it's called under that legal system, based entirely on the length of stay. But whether the statute does permit him to apply for a formal grant or a formal certificate or not, the best way to describe his title to the land is a prescriptive title. Now, if you look at our colleagues in property law, I think there was a time they were discussing the new I think land registration law of Lagos State. I think the new land registration law of Lagos State has a provision for the person who becomes owner by sheer length of use or occupation or possession to apply. Okay? Go and look at that their new law. There is something like that there. We are not saying that that is what makes the adverse possessor to be entitled to a prescriptive title. Okay? The mere fact that the law would extinguish the right of the otherwise title holder after a length of time, okay, entitles the adverse possessor to a prescriptive title. It's only that statutes may differ on whether he can formalize that title by applying for a certificate or not. Okay, but whether the statutes provide for a right to formally apply or not, he, the adverse possessor, is said to have acquired a prescriptive title to that land, because otherwise the new owner can no longer go to court. The relevant limitation laws have extinguished his title. Okay?
You're on the road.
Is it clear?
Yes, sir. So I have some questions, sir. I don't know if I can. Yes.
Yeah.
First of the question is this, particularly on this. My name is Bumidera Ramola.
Okay.
The question is with regards to adverse possession. In the course of the presentations, I was looking at the economic implication of this particular concept. Now, sir, land banking is a business. People invest in land and for storage purpose, and when it is appreciated, they take the land back to market and sell, then make money. Now, if this concept is not regulated, like it's allowed in totality, like you rightly said, in Lagos here, we've had a client who owns the land in Chevron, and he was in the land earlier than 3 months, and on the 3rd month he got to the land. A construction was already at roof level. Then, if we say because of what he has done something magnificent on the land, or he has accessibility some rights within some time, then as a result of that, that person is entitled or has a defense, as equitable defense of laches and acquiescence with regard to adverse possession. I think that deprives or reduce the economic value of land banking to nothing. That's my first question. I want to know your opinion on that. Yes, sir.
But let me answer this, your first observation.
Yes, sir.
Okay? Let me answer your first observation. You said he came back to the land within 3 months, he found that something has been completed and all of that. You know, I told you that it is the conduct of the parties that the Court of Equity will be looking at. Do you understand?
Yes.
He may not be guilty of standing by. He may not be guilty of standing by. Everything will depend on the facts presented before the court. If it is obvious, then the adverse possessor may not even be entitled to that defense, because he might have moved onto the land knowing full well that there's something illegal about the way he had acquired the land. Most of the time when people rush to develop like that, they only shift burden of proving their finding to you. You are able to show that the real reason why he quickly went onto the land to start developing is for him to present to you a fait accompli. Okay? So, conduct-wise, the Court of Equity might not find you guilty if genuinely you were not aware. And so, he might not be able to use defense of laches and acquiescence against you. But that is different from a situation where for good 10, 11, 12 years, for God's sake, if you have land and 10, 11, 12 years, you don't even go there, how can you blame somebody who has been deceived to buy the land and who has built there and is living there? So everything depends on the circumstances. You want to bank on your land, then you should watch over it also. That's what this concept is teaching us. If you have invested so much on land, don't keep away from the land. Be conscious and knowledgeable about the development there, so that when something is brewing and somebody is falsely presenting your land as his own or selling it, you will quickly know. Maybe some 2-3 months is not long enough for that your friend to deserve the punishment. That will be for the court to decide, because the circumstances of acquisition will also be looked at. Unless the court can find that some conduct of his is condemnable and would amount to standing by, the defense of laches and acquiescence may not succeed against him. If, for example, is able to show that it was within 2 or 3 months that this person rushed this thing up to this stage, that in itself might be a proof that the man possibly knew that he didn't acquire the land properly and wanted to foist on the real owner a fait accompli, so that maybe when the person gets there, he will not even identify the land again and all of that. So it is the conduct of both parties that the court of equity would examine. And irrespective of whatever amount your friend would have spent, if his conduct has led to a situation where somebody was misled, it is for equity to determine who between the two of them should suffer. And that is why in deserving circumstances, equity will allow the possessor to raise a defense. If you look at the facts of Awu and Cookie Gam, the plaintiff was aware of all the development that was going on the land, but was banking on his title. And so that resulted in making the person who was wrongly developing the land to believe that he acquired rightly. So what the law is simply saying is that if you invest on land, don't keep away from the land. The moment you see anything happening which tend to contradict your ownership of the land, take step. Take step. If you have record that before he even started fencing, you informed him. You have record that before he even started fencing, you went to court. Anything he does thereafter cannot be a basis of building a defense of laches and acquiescence. Is it clear?
Yes, that is clear, sir. I don't know if I can go to the second observation, sir.
Go to the second one.
Thank you very much, sir. Sir, I just want to examine this. You know, our law recognize prescriptive title, so to say, because even the statute of limitations says one or two things about that. But this same adverse possession, sir, it became notorious by virtue of the Supreme Court decision in the Dudu and Okumagba. That decision was reached in 1976, before the advent of the Land Use Act. Then, for me, I'm kind of confused. What is the implication of adverse possession vis-a-vis the Land Use Act requirement for passing of title? Can adverse possession be recognized in view of section 22 and 23 of the Land Use Act? That's pushed some kind of question into my mind, and I felt, for me, I don't see adverse possession being successful in view of those provisions. So I want to get your
Well,
views. Yes, sir.
first of all, let me,
Yes, sir.
I'm not an expert in land law, but I
Thank you,
know
sir.
that case you are talking about is only talking about, is it not the one talking about the way by which people can acquire
Can
ownership
prove
of land?
title. Yes, yes.
Yeah.
And it listed adverse
It's not,
possessions
sir,
as one of it.
sir, it's not talking about adverse possession, it's talking about long possession. They are
Okay.
two different things. Long possession. He's saying that I think he talked about 5 weeks, and one of them is that you have been on the land for so long, and all of that. You have the right to plead that the land is yours, and all of that. It's not, that one is different from adverse possession. So don't confuse it with adverse possession at all. And even the land user that people are talking about, the land user recognized previous title now. That's why you have the deemed right of occupancy, the deemed statutory and deemed customary right of occupancy. Those who have been on land long before the Land Use Act came, there's a recognition of their title. Okay? And so that's why today when you go to court, you will say that you are the person entitled to be deemed as the right of occupancy holder. I don't know what you mean when you say that Land Use Act abolished adverse possession as a right that can be asserted. Well, what Land Use Act does, which is very clear, is to grant radical title to the governor, which the governor would exercise as a trustee of all the citizens of a state. But that does not mean that previous owners or previous occupiers cannot place value on their length of possession. So Land Use Act, in my own view, does not have the implication of contradicting adverse possession. What I know is that at first, when the Land Use Act was enacted, there were those who even believed that ordinary possession confers on you superior title as against your grantor. But the cases came later to come and explain no, that Land Use Act does not they call it enfranchisement, does not disenfranchise the original owners. If there is a deal, if you are in land because of a deal, maybe you are a customary tenant or whatever, it doesn't convert you to an owner. So there is nothing in the Land Use Act that has done away with the value of possessory right, with the claim that a long possessor might be able to make. So, well, that is my own way of answering your question. But in a jurisprudence class, what are we concerned with? We are merely concerned with the implication which physical possession has. And the reason why it's often said that it is 90%, either 90% of the law or 90% of ownership. Okay? That even some of the time when you don't have a title, your root of title is defective, the mere fact that you are in possession might confer you a superior claim as against the real owner, either in the sense of offering you a defense, or sometimes statute will outrightly prescribe you as the owner because you have remained in possession for a given length of time. That's our own concern in this class, okay? It may well be that when you look deeply in land law, you will be able to explain further what we are saying. But the truism which a jurisprudence class wants to prove is that sometimes you are not the owner. What you have is mere possession, mere physical possession, de facto possession, okay? But you are also able to exclude the real owner, okay? You're able to exclude the real owner from claiming ownership, either in the form of being able to raise a defense, or sometimes statute outrightly extinguishes in your favor the ownership of the real owner. Okay? Are you satisfied with that, my explanation?
Yes, sir. Thank you very much, sir. It's good, sir. Thank you.
Okay. So let's move to, can we really move to another topic today? This is already 1827 by my phone. Okay, let the, can the presenters of theoretical basis of thought, can they do that within the next 30 minutes? Or we just take it that we start afresh with the theoretical basis next week?
Okay. Good evening, sir.
Yeah.
My name is Shaba Olakemi Olawumi. I'm of
Yeah, what?
there are two other group 8, sir. Group 8.
Okay.
And our topic is theoretical basis for thoughts.
Okay.
If it's possible, I would like for us to quickly, although it didn't occur to us now that I'll be presenting on to this morning, but if it's possible, I would like, I'm happy that I quickly present the paper, sir.
The meaning is that your task is not done until next week. If you start now and one of you is not present next week, we will mark that person as not having presented.
Okay, sir.
Okay.
Is it okay for us to move it to next week, sir? Or may I ask that we move to next week?
That's actually
I will suggest that we move it to next week, sir, so that we can start afresh.
Go and study your paper very well so that you speak to it within 30 minutes and we can have a discussion of 30 minutes. Then the people in contract will speak to their own paper within 30 minutes and we have another discussion of 30 minutes. Okay?
That's fine, sir.
So I see you next week.
Good night, sir.
Okay. You're welcome.
Yes. Good night.
Yeah.
Thank you, Prof.
Good night, sir.
Thank you, sir. Good night. Thank you, sir. Good night.
Thank you, sir.